Good afternoon. My name is Matthew Talbot, and I'm an elder law attorney in Walnut Creek, California. Now, we've been talking about trusts, and today I wanted to talk about ways that people can contest the terms of trusts. By that, I mean sometimes people come to me and they say, I'm the beneficiary to a trust, and there was a first trust that was done, and I was 10% of the share, and there was a second trust that was done, and I was 5% of the share. But I don't think the second trust is really valid, and I lose out on money, 5%. So I want to contest that second trust and try to invalidate it. So how are the ways? There's really two main ways that we handle these types of matters. One is we try to argue that the person who signed the document, who is now dead, did not have the requisite capacity to understand what they were signing. Now, these can be complex documents, and sometimes they're simple documents, and there's a whole legal scheme set up relating to whether it's complex or simple. But the basic understanding is that the person signing had a mental deficit or inability to understand that they were signing a document, distributing assets, or naming a beneficiary, or naming a trustee, or whatever the document does, and that they truly were not signing the document. This can get extremely complicated because a lot of people are in a gray area mentally. They don't believe it's 1952. They don't believe, this thing or that thing that makes it obvious that they lack capacity, but they have mild or moderate cognitive impairments. And this makes it seem as if they do have capacity when perhaps they don't. So that's the first way. The second important way to invalidate a trust or trust amendment is what's called undue influence. And put very generally, this is when a person applies significant pressure on the person signing the document to either sign or in some instances not sign the document. Now, this is a very complex legal scheme, and I could spend an hour analyzing this. I want to just be more general. An example of this might be somebody who does an estate plan late in life, and at that point a child is living with them and providing care as a caregiver, and the child says, mom or dad, whomever, if you don't sign this will or this trust, I will stop providing food, I will stop providing care, medicine, or if you don't sign this will, you don't love me. And if you loved me, you would sign this will. And maybe they don't say it one time, but they say it over and over and over again, and they provide that pressure. That, of course, is inappropriate, and it's called undue influence. And what that means is that the elder signing the document may have understood what they were signing, but they did not feel like they were signing it of their own free will, or they're doing it due to the pressure of the alleged abuser. We handle a lot of matters like that at this firm, and it's always very sad. But unfortunately, sometimes in certain families, these types of things exist. So what we're looking at today is lack of capacity and undue influence as two ways to potentially invalidate a trust or trust amendment or will to go back to earlier documents. Thank you very much.